Hello, hello, hello. This is Attorney Mike Craven coming to you from Chicago as usual, and we've got something special today. Oh, first I want to say thank you to Mikhail and Lauren in the Discord. They teamed up. Meg was also got it for me. We've got a hearing with the cranky attorney. We've got contempt. We've got a disgusted walk off. Let's get this party started, shall we?
There we go. And we just came back on the record. Is Alexia Law Firm, which is present here,
That's you, Lauren, right?
able to connect into the Zoom hearing? Turn on your camera and your mic.
How's that?
Great. Well, I can hear you now. That's wonderful.
Okay. I'm so sorry. I just have the worst cold, Your Honor, and may it please the court. I respect you immensely. So,
sure. So we were wondering, we've had a little bit of a hearing going on here, and we didn't know whether you were representing Mr. Meeks at this point.
only Mr. Meeks. I represent no entities whatsoever. Only Curtis Meeks.
Okay. So, thank you for making your appearance.
I'm so sorry, Your Honor.
It's fine. Mr. Watts will be excused. The order will stand that if Mr. Meeks does not get a lawyer to represent his LLC, that his answer will be stricken. So please prepare an order. Who would prepare that? Mr. Coomer, please.
Yes, Your Honor.
An order reflecting that decision. And hopefully it can be impressed upon Mr. Meeks, because I did a file review on the.
Okay, just a quick interjection here. I haven't seen this, but the fun's already started. She said I'm appearing only for him, which is appropriate. That's the scope of her representation. And the judge is already very nicely, but just like, well, let's knock that stuff off right now because this involves an LLC. So unless he gets an attorney in here to represent the LLC, then his answer is going to be stricken. In short, he's going to lose. I knew this one was going to be bad. I know it was so bad that I had to bust out the Justin Richard Clevenger, oh man, I got to get it together mug from Covert Design. And yep, I had to put a cocktail in it.
Break, that there's been a lot of opportunity for Mr. Meeks to please get a lawyer for your LLC, or it's going to be very bad news. There's just not much else that anybody can do. And it's a very important thing. And I think maybe, well, that's the ruling of the court on the motion to withdraw. It is granted. Mr. Comer is going to draft the order. You're excused, Mr. Watts.
Thank you very much, Your Honor.
Thank you. Mr. Comer, you may proceed on your motion.
Okay, thank you, Your Honor. Would you
And just for the record, and for people watching, this is against the individuals, Ricky Henderson pro se, and Mr. Meeks, who's represented by Miss Mia Alexa, I believe.
Alexia.
All right, Mia Alexa.
It's Alexia Law Firm.
Okay.
And so we only represent Mr. Meeks individually, no other entities.
All right. Miss Alexia, did you have time to, now that you've made an appearance on behalf of Mr. Meeks in his individual capacity, have you had a chance to review the motion for contempt?
I have. Would you like a response, Your Honor?
Okay. Well, let's go with Mr. Coomer's opening. He's given, you may proceed, Mr. Coomer, on your motion for contempt.
Okay, thank you, Your Honor. Mr. Bueller, will you put up our PowerPoint presentation, please? Okay. Thank you, Your Honor. Basically, this started on December 30th, 2022. A TRO was granted enjoining Curtis Meeks and his agents from selling or transferring the property, the Denfield property, that is the subject of this litigation. This TRO was granted on December 30, 2022. Since that date, the TRO was extended, and then a temporary injunction was granted and is currently in place. On January 3rd, 2023, less than 2 hours after Mr. Meeks and his agent, Mr. Henderson, were personally served with the TROs, they violated the temporary restraining order. Since January 3rd, 2023, both Mr. Meeks and his agent, Ricky Henderson, have been given numerous opportunities to purge or cure their TRO violations, but refuse to do so. All they need to do is sign a special warranty deed that transfers the property back to AACSI Investments, where it should be. On December 30th, 2022, the court issued a TRO against Curtis Meeks and Ricky Henderson. Mr. Meeks and his agent were enjoined from enforcing an illegal and fraudulent deed of trust, as well as performing any of the following acts. The exhibit is D9, and basically you can see they prohibited from transferring, conveying, assigning, deeding, or otherwise disposing of or damaging the property. We know they were served by the constable at 9:50 a.m. on.
I mean, this could be done with judge. They transferred the property after they were enjoined from doing so. Next.
On January 3rd, 2023, they were personally served with the writs of TRO. They are the exhibits A and B to the motion for contempt. Both were served at the courthouse while attempting to have the constable foreclose on the property at the public auction. I'll go over that exhibit when I take Mr. Meeks's testimony. Mr. Meeks originally filed a response to my application for a TRO, so he clearly knew the TRO was coming. Curtis Meeks and Ricky Henderson also attended a temporary hearing on January 12th, 2023, where they were shown the TRO. I explained to them with a PowerPoint presentation how they violated the TRO, and the judge at the hearing clearly instructed them to attend this hearing today. She issued a show cause order and recommended very strongly that they both hire counsel for this case. So I'm kind of surprised how long this has taken, because this is over a month ago, but they clearly had notice of the TROs. They violated the TRO less than 2 hours after it was served on them. There's 4 different violations of the TROs. I'm going to go over them.
Well, they waited
Basically,
2 hours.
on January 3rd, 2023, again,
Which is nice.
approximately 2 hours after they were personally served with the TRO, Curtis Meeks directed his agent, Ricky Henderson, to administer the deed of trust. Basically, they enforced an invalid fraudulent deed on the property. This is a violation of Section 2A of the TRO. This is violation 1. And if you look at the trustee's deed, D8, you can see that there is a clear violation as in the deed records themselves and the trustee's deed. Let's go forward to number 2. We had them served through on the temporary injunction, on the show cause, on the TRO, through the constable's office. And in serving the TRO, the Travis County Constable tasked with conducting the public auction foreclosure sales was notified of the TRO and said, hey, we can't go forward with the constable auction foreclosure sale. However, once they figured this out and they were served with the TRO, Mr. Meeks and his agent, Ricky Henderson, drafted this trustee's deed, giving the false impression to the public that the sale was conducted at the legitimate public auction. They actually even put the sale location in the deed to make it look like the constable's foreclosure sale, but it was not. We can move forward. This sale was not conducted by any court. Therefore, it was a non-judicial sale of the property. Conducting a non-judicial sale of the property violates Section 2B of the TRO. That's the second violation of the TRO. And okay. The third violation of the TRO is the fraudulent deed purportedly sold, transferred, conveyed, assigned, deeded, and disposed of the property by seizing it, levying it, selling it. They also violated Section 2C of the TRO. This is the third violation of the TRO. All three of these violations can be seen in the trustee's deed, which is public record, and I will take Mr. Henderson and Mr. Meeks's testimony in a few minutes, and we can prove that up. But violations 1 through 3 of the TRO can clearly be seen from a review of the TRO and the January 3rd, 2023 trustees.
It goes sideways.
Also of
Takes a
note,
little while.
this is the second time Mr. Meeks has attempted to transfer this same Denfield property from AACSI to Top and Ball Properties LLC. He did it the first time through a deed of trust back on February 2nd, 22, without any consideration. And he,
Objection to hearsay.
Well, this is his overview. You're going to get your opening statement too. So, or you can do your opening statement at the start of your case in chief. I mean, your case in chief. Your
Correct,
response.
Your Honor. You're correct.
Okay.
thank you.
Okay, that right there is already weird. You don't affirm the judge. You're correct, as if you're in a position. You're not the judge's professor. The judge knows she's correct.
Basically, if you look at either the deed of the quitclaim deed or the trustee's deed, you'll see that both of them were transferred without any consideration, thus making them fraudulent transfers. Additionally, Mr. Meeks appears to have violated the TRO a fourth time. On January 11th, 2023, Curtis Meeks sent an email to me that included an attached loan agreement that purports to encumber the property. This loan agreement, which appears to have been created in 2023, violates Section 2C of the TRO, and it was committed on January 11th, 2023. We have D19, which we'll go over, which is the loan agreement. It purports to have been signed on October 30th, 2020. But in looking at it, you'll see that there is a copyright date in the document of 2023, making it impossible for this document to have existed back on October 30th, 2020. And impossible for anyone to have signed it then. The document has several other issues, including it doesn't have page numbers, the fonts don't match. Also of note, I'm aware of Mr. Meeks having litigation, including criminal and civil cases, where there were allegations that he created false documents or forged documents.
I would object to that as character evidence, but moving forward.
Okay.
Oh my God, I didn't see this before. She is nuts. She's not in charge with that little intonation. First of all, he's giving an opening statement. Your objection's completely out of bounds. And then this pretending you're in charge of something. You're not. To the extent you could possibly make an objection, go ahead and say objection and then wait for a ruling. But you're not directing when we move forward or not.
If we can go back one slide, Mr. Bueller. We can go over Exhibit M in our supplemental motion for contempt. If
that was something.
The court wants to see it in our supplemental motion, Exhibit M goes over why we believe this loan agreement is fraudulent. If we can move on to the
Ooh,
next
she might
slide.
be.
Additionally, we've given
I
Mr.
don't
Meeks
know.
and
I don't
Mr.
I don't even know if that's what
Henderson
you're suggesting,
multiple opportunities to cure and purge the TRO.
Also, Your Honor, so counsel respectfully, he is characterizing my client as being involved with the other person. So that is not
probably because he
accurate.
is.
But let's move forward.
I'm just trying to give the court an opening.
Overruled. Go ahead.
Oh
Okay.
no.
Since
I don't represent Ricky
did it
or whatever
again.
his name is, Ricky Henderson. So let's just focus on Curtis Meeks and and let's move forward.
Oh, she is so out of line. She is so out of line. She might be altered. She might be drinking. I don't know. I'm not, but like that is so out of line already. Okay.
Okay, my motion for contempt is against both gentlemen. And
But that's not.
Okay,
a-
okay, Ms.
And the judge gets it. She's smart.
She did.
She gets it.
Okay.
Mr.
All right,
Miller,
let's stop interrupting. This is what he intends the evidence to show. If he doesn't show that, then you can hit him on argument.
thank you. Since January 3rd, 2023, Curtis Meeks and Ricky Henderson have been given numerous opportunities to cure or purge their TRO violations, but they have intentionally refused to abide by the court's order. On January 6, 2023, after I found out that they had violated the TRO, I sent an email message to attorney for Top and Ball, providing notice of the TRO violation and providing Top and Ball and its sole member, Curtis Meeks, the opportunity to transfer the property back. This email message was ignored.
By whom?
It was ignored by attorney for Top and Ball, and his client was, Top and Ball's sole member, manager, and owner is Curtis Meeks. If we could move forward. On January 11th, 2023, after a motion for contempt and motion for show
That's
cause
plausible.
was filed by Movements, another email message was sent to the attorney for Top and Ball, providing Top and Ball and its sole member, Curtis Meeks, another opportunity to transfer the property back. This email message was also ignored.
You're presenting this as the opening statement, right?
Yes,
Okay.
I am.
Ma'am, I'm
Right.
sorry. Please stop interrupting.
Seriously.
You may proceed, but okay, come on, wrap it up. So we have 4,
I will.
government, fraudulent deed, the
From what I've seen from this attorney, I think he's pretty good, but I hate the use of a PowerPoint here. Just say it. These guys are doing a bunch of fraudulent things, but specifically they invaded property fraudulently, made up a deed. There's a TRO against them transferring the property. Next.
deed of trust, and then the non-judicial sale. So what else do you have?
Okay, I have that on January 12th, 2023, we had a hearing. Both Mr. Henderson and Mr. Meeks were there. I explained to them how they violated the TRO. I asked them to sign the special warranty deed to
Well, no one
transfer
told
the
her that.
property back. They refused. We had to have a show cause issued, and we're having to have this hearing yet again where we're Groundhog Day, where I'm saying, hey,
No.
transfer the property
That's insane.
back through a special warranty deed. You clearly violated the TRO. It's been explained to them. Okay? On January, if you can go back one more time, Willie. On January 20th, 2023, I sent another request, this time to Curtis Meeks' email address and to the Top and Ball attorney, giving him yet another opportunity after the January 12th hearing to transfer the property back. This is Exhibit D16. He knew he had opportunities. I got a response from Curtis Meeks and Ricky Henderson. And basically the response I got from Curtis Meeks used several laughing emojis and just kind of ignored my request. I get the idea he's laughing at us. And then he basically is making false accusations in his response. So it's clear.
State your name for the record, ma'am.
My email requesting the property be transferred back, and it's clear that they're refusing to cure their violations of the TRO. We can move forward. Since January 3rd, both Mr. Meeks and Henderson have had clear notice of their TRO violations. They've also refused to cure or purge their violations.
Yeah, I'm
I
getting
don't
that
think
feeling
either
too.
one of them will voluntarily cure or purge their violations without a court order. And just as a side, it's clear from doing research on both of these gentlemen, they both understand TROs and court orders. They've sought them in the past. So this is them just thumbing their notes at a court order. They both violated these orders. They both were clearly served with the TRO, had clear notice of their violations. They've had several opportunities to cure their violations, but refused to do so. And basically, these not complying with these orders, it's not a mistake. This is intentional.
All right, you're getting into you've made your
Okay.
outline.
Okay, and just one more. What we're requesting is Curtis Meeks, as sole member of Top and Ball, signs the special warranty deed, Exhibit E, within 24 hours of this hearing. And then if he doesn't do that and file it in the public records, then he is fined $1,000 a day until he does that. We're also going to seek
Anything would be too
attorney's
much.
fees for having to chase this property for these violations and motion for contempt, but I'm fine with having the attorney's fee section of this at another date.
So you're reserving.
I am reserving, Your Honor.
All right, will you close your, thank you. All right,
Yes,
Miss
please close it.
Alexia.
In substance, the guy is fantastic. Everything he's saying is right, and he's laying out his case, but he's being too. It's an opening statement. Spit it out. You're in front of a judge, not a jury. You're losing everybody. You got a winner. Just spit it out.
Yes, Your Honor. So I am new in the case, but I will submit to the court that my client alleges that Brenda Walston and Walston Homes was skimming off the top. There is a discovery issue, Your Honor, where they were skimming off the top and stealing from my client, Curtis Meeks. We would like to proceed with discovery. Top and Ball Properties is a separate company of Curtis Meeks. Curtis Meeks, by the way, Your Honor, is a professional boxer. So he's a pretty impressive person. I do not represent Ricky Henderson. The lawsuit is asking
Oh my
or
God.
involved in
She's
that
up
matter.
talking.
I have no involvement with that.
I don't know. She does sound drunk to me. I'm being honest.
SI Investment Companies is a quagmire of a nightmare, in my professional opinion. I do not represent them whatsoever, and nor do I represent Top and Ball.
A quagmire
You've
of a
said that
nightmare.
4 times now.
Correct.
Okay,
We've got
it
another
is
t-shirt.
very clear. It's already on the record who you represent.
Love it.
What, do you want to do your opening statement responding to
Love it.
Mr. Coomer after his case in
Yes.
chief, or you want to go now?
Yes, Your Honor. I
Okay.
represent Curtis Meeks, and I take my ethical issues very seriously. I do believe that there is profound evidence to show that there was skimming off the top as a builder in this
Profound
case.
evidence. Just evidence.
There was skimming off the top. The reason why
We've
I'm
heard.
saying this
Oh, she's
is
drunk.
that
It's got to be.
Curtis Meeks Although he may have a history, he was
That's another possibility.
he entered into a joint venture in real estate. Ricky Henderson, I don't know him from Adam, nor do I represent him.
Oh my!
There should be
so
no
inappropriate.
contempt of court toward Curtis Meeks.
He should
That's
be
what I
held in contempt
pledged
for
to
the
the
way
court.
his
He
posture right now.
cured
Right there.
a deficiency that was financial. Curtis Meeks cured a deficiency financially,
All right.
where he entered
get-
into a joint venture
Get another
and his
cocktail so I can
partner
just
stole
understand
from
her.
him.
All right, Mr. Coomer, you may call your first witness.
Thank you, Your Honor. We call Curtis Meeks as a witness.
All right, Mr. Meeks, can you please raise your right hand?
Yes,
So, do you solemnly swear or affirm that the testimony you're about to give will be the truth and nothing but the truth?
yes.
All right, you may proceed, Mr. Coomer.
Thank you, Your Honor. Could you please state your full name for the record?
Curtis Lee Meeks Jr.
Okay. And Mr. Meeks, how long have we been litigating this case?
I mean, it was going for a while because we was going for a lien. It was a lien, and then it just turned out to be this. So it's been probably about 2 years now because you wanted to go this long. So I guess we'll just keep going.
Did you hire Mr. Darwin McKee in 2020 to file this lawsuit?
Yes, it was a AACSI with me and Alan Guyton, but he doesn't control any of that. But we hired Derwin McKee and CQ Gary, but you convinced Alan to tell the courts that them lawyers wasn't yours, that was only Curtis. So the judge went on ahead and said that AACSI don't have counsel, then we can't do nothing about it. So you convinced Alan to do that. So that's why we're here today, because AACSI couldn't get counsel. So if AACSI don't have counsel, then I guess the courts are, I guess, go with y'all, I guess. I don't know.
Okay.
Yeah, thanks.
Thank you,
Mumble.
Mr. Meeks. And if you could focus on the questions I'm asking moving forward. So overall, how many attorneys have you hired to represent you in various capacities in this case?
Objection, character evidence.
Well, I
What?
would say relevance, but just to
No,
answer the question, it overruled as to that.
I
It might be
answer- I
mildly
answer the
relevant, but I
question.
don't know. Go ahead and answer.
Curtis, please do not speak
can
over the
answer.
judge. Please do not speak over the judge, okay? Thank you.
What'd you
How
say,
many
Coomer?
attorneys,
Go
Mr.
ahead and say it
Meeks?
again. 3. If I'm not mistaken. 3, 2 for ACSI, and 1 for Top and Law.
Okay.
Okay. These attorneys a goof, but I do get where she's coming from with the character evidence that because he's asking the question to say that the guy's had to have a bunch of attorneys because he's a goof and he's full of it, and the attorneys don't want to hang with him. That's why he's asking the question. But I understand where the judge is saying relevance is also a good objection there, and probably the better one.
Did you hire-
7 or 8, but that's wrong.
Could it be 5 attorneys, including Darwin McKee, Anthony Arguya, Sekou Gary, Jameson Watts, and now me, Alexa?
The one on the case was Derwin McKee, which you told him to get fired. You told Alan to go against them. So Derwin McKee and CQ Gary. And after they got off, I had to hire another lawyer for me. Now I had Nikhil, which is Jameson. And then we filed a motion. Now we got Mia.
Okay.
Anthony was never on the case.
So yes or no? 5 attorneys so far.
No.
Okay. How is that wrong?
Okay, well, you can go to the next question.
Okay.
Curtis, so we're gonna focus.
Okay. Through this litigation,
All that's inappropriate. Okay, the client can't. He's being examined right now. He doesn't direct when the attorney goes to the next question. Then she's not supposed to be coaching him right there. Although in this particular circumstance, the judge lets it go, and I would too, because she's trying to help. But the whole thing is so awkward and wrong.
concerns two two-unit condominium located at 1132 Denfield Street in Austin, Texas.
Say it one more time, Kuma. Somebody was called. Say it one more time.
Okay, are you familiar with the Denfield property?
Yes, the one I spent over $900,000 on.
Okay, just
yes, I understand.
okay.
Yeah, no,
okay.
you're asking, so I'm telling you. Yes,
I'm trying to streamline this, and I'm saying, are you familiar with the Denfield property? Yes or no?
Yes.
Okay, and is this lawsuit concerning this Denfield property? Is that correct?
Yeah,
Well, I thought the lawsuit was for a lien for $250,000. That's what we
They might
was
have been
going to
drinking
court
together,
for,
who
because
knows?
I wanted the judge to tell me if that was a lien valid or not, because y'all put a lien on there for no apparent reason. So we was going to court because I'm the one that sued her to see if this lien was valid or not. But then you went on ahead and told Alan what to do as far as don't say them your lawyers, say it's them are Curtis lawyers and stuff like that. So yes, I do understand everything you're talking about. But go ahead to the next.
I'm going to object as non-responsive and try that again. Okay, is this?
Overruled. You need to object to non-responsive as soon as you start seeing that it's non-responsive, okay?
I will, Your Honor. Okay.
Because that was after one word.
I will do that, Your Honor. Mr. Meeks,
give me an objection to rule on. It was making me crazy, but you didn't object.
are you in control of the Denfield property right now?
I'm going to always be in control of it because it's my property.
Okay.
Regardless of what you say or whoever else says, it's my property. I spent over $900,000 cash money. That's mine, of course. I mean, why wouldn't I?
Okay. And do you understand my client's claim to be the builder general contractor of this property?
I don't know your client
He
from a can of
doesn't.
paint.
He doesn't understand.
Okay. Okay.
Well, that's not an objection.
Yeah.
I know. I'm sorry, Your Honor.
Stick to the rules of evidence and procedure and case law and statutes and constitution.
Yeah, go ahead and maybe start acting like an attorney, for instance.
Mr. Meeks, have you seen the building permit for this property that lists my client as the builder general contractor?
She did. She could have been a builder contractor with Alan Guyton and Mike at Park Place Funding.
I'm going to object as
Mike
non-responsive.
Well, I ain't seen nothing. I just seen some paperwork saying they finna get foreclosed on. That's
I
all. I
understand. So you haven't seen the building permit listing my client as the builder general contractor, correct?
Asked and
No,
answered.
no.
Okay.
Overruled.
Do you
Yeah, he said he saw the paperworks.
understand my clients want to be paid for their work in building these luxury condo units?
Assumes facts, not in evidence.
Overruled.
Let me answer his question when he asked it. Say it again, Kuma.
Okay. Do you understand my clients want to be paid for their work in building these luxury condo units at the Denfield property?
Once
Well, she
again,
put a lien on for $250. I wanted to pay it then.
Curtis,
I want to pay $250,000.
repeat.
Excuse
court
me.
got to tell me.
Excuse me. Miss Alexa, please. If you open your mouth again and words come out other than objection and then a rule, statute, rule of evidence,
Objection.
etc., doesn't come out after it, I'm going to hold you in contempt. I'm tired of this. You don't get to just stop and start instructing the witness. And you've done it a couple of times too, Mr. Coomer. There is a procedure. And we're going to get due process here. Next
Understood.
question.
Okay. On February 16th, 2022, did we have a hearing in this case where Judge Doty granted discovery sanctions against AACSI Investments LLC and the attorneys you have hired to represent AACSI?
What you mean?
I
Like,
mean,
just say it again. Like what?
did we have a discovery motion to
talking about,
compel
Laura?
and sanction hearing last February 16th, 2022, where Judge Cleve Dottie issued an order sanctioning AACSI Investments LLC and the attorneys you hired for AACSI regarding discovery abuses?
Yes, they said we had that hearing back then where, what was it, February, you say February 6th, where the judge said I couldn't hire them lawyers. I don't know why, because AAC and I both had to have counsel.
Okay.
And
to be clear,
you told Alan not to them ain't your lawyers, Alan. Just say them ain't your lawyers.
and to be clear, there was a prior order issued on February 18, 2022 from Judge Cleve Dowdy in this case, correct?
What are you trying to get to, Kuma? Yeah, like what's going on?
Okay, and as part of this order, AACSI and your attorneys were ordered to produce all relevant documents related to the Denfield property within 14 days. Is that correct?
Say that one more time.
Okay.
You went a little bit too fast.
Okay. We had a discovery hearing last February 16th, 2022, at which time your attorneys and I went before Judge Dowdy, and he heard our arguments, and he said AACSI Investments, Inc. needs to produce all documents related to this Denfield property. Is that correct?
Yes.
And AACSI was ordered to do this within 14 days. Is that correct?
Yes.
And is it true also that Judge Dowdy sanctioned AACSI Investments in their attorneys at that time, ordering them to pay attorney's fees? Is that correct?
You said sanctions?
Sanction.
Pay attorney fees?
There was a sanction
Yeah, you
in the
told them
order.
What?
You know it's correct when he tries to deflect it like that. Wait, what was it? What'd you say? Sanctions?
You talking about the $3,000 one?
I'm talking about the first one that Judge Dowdy issued in February 2022, not the second one he issued on June 2nd, 2022.
I just know it's the only one for $3,000. That's all
Okay.
Yeah.
Okay.
We don't care. Answer the question.
Let's switch topics here. On February 2nd, 2022, did you execute and file a quitclaim deed attempting to transfer the Denfield property from AACSI Investments LLC to Top and Ball Properties LLC?
Yes, I went to go record it with a quitclaim deed and Top and Ball, which is my other company. AACSI is my company too. But I put in Top and Ball, and you told the lawyer to tell Mr. Meeks put it back into AACSI. And that's what I did. Put it back into AACSI.
Okay. Mr. Bueller, could you put Exhibit D2, the February 2nd, 2022 quitclaim deed up on the screen? Mr. Meeks, do you recognize this quitclaim deed marked Defendant's Exhibit number 2?
What about it?
Do you recognize it?
I say, what about it? I'm gonna recognize anything. Say quitclaim deed. What you want me to say?
Have you ever seen this quitclaim deed before?
My name is signed on there, and I got to recognize it.
So you do recognize this quitclaim deed?
Yes.
And that is your name. You signed this quitclaim deed on page 4 of exhibit number 2?
Yes, I signed it, Coleman.
Okay, can we move up to page 1 of this document? Do you see the highlighted parts of this document?
Right, that both companies are mine. Well, I'm half in ways since that you told Alan to tell the lawyers them not your lawyers, and we was going for a lien, but you told Alan to go otherwise.
I'm saying, do you see where this quitclaim deed has you listed as the grantor, Curtis Meeks Jr. of
Oh, he doesn't-
AACSI Investments
legitimately doesn't
LLC?
understand.
Do you see that?
Do Miss Brenda Walsh's name supposed to be on there or something? Because you talking like this is y'all building, like it's y'all money and it's y'all property. I mean, that's how you talk.
Mr. Meeks, I'm only showing you the quitclaim deed that you're familiar with and you recognize through your personal knowledge. And I'm making sure that you and the court can see that you were the grantor on this quitclaim deed. Is that correct?
So basically, you want to put Miss Brenda's name on there. That's what you're telling me? Because I mean,
No,
we
I'm
seeing
not
everything
telling you that at all.
You got to be
doesn't know how to
saying that.
control
You
witness.
said he's trying to
Objection
get
to
something
badgering
that
of the
ain't yours.
witness.
Overruled.
Mr. Meeks, can you just answer the question? Can you see that you are listed as the grantor on this document?
I see I am the owner of the whole property.
Well, the document clearly says grantor's name and address, Curtis Meeks Jr. of AACSI Investments LLC. Did I read that correctly?
You read it correctly.
Okay, and then it says the grantor's name is Curtis Meeks Jr. of Top and Ball Properties. Is that correct? Did I read that correctly?
Top and ball.
Right, you read that correctly too, Coleman.
Okay, and the
I don't
other
wanna
part,
know.
in consideration of the sum of $0 paid to Top and Ball Properties, did I read that correctly?
You read that correctly too.
Okay, and just so we're clear,
Colin.
are you the sole member of Top and Ball Properties LLC?
Yes.
Does that mean you're the sole owner of this LLC?
Asked
I'm
and answered.
100% owner.
Objection,
I'm 100%
asked and
owner.
answered.
Sustained.
Okay,
Thank
and
you.
are you the only manager of this LLC?
Asked and answered.
No.
Objection.
Is it true that through this quitclaim deed marked as D2, that you attempted to transfer the Denfield
Oh,
property
don't worry.
from AAS
It gets so much worse.
Investments
So much worse.
LLC to Top and Ball Properties?
Objection assumes facts, not in evidence.
Objection. Up talking. I'm gonna lose my freaking mind. Okay,
Overruled.
I'm better.
But it's asked and answered, but answer it again.
Thank you.
Mr. Meeks,
Yes, ma'am.
do you need the question read back to you, or would you like Mr. Coomer to ask it again?
No,
No.
he doesn't need the question answered back again.
All right, then he needs to answer it.
Oh yeah. Oh yeah, it does. Andrew, you're gonna love it.
What you want me to answer? I answered it twice.
What was your intent in signing and filing this quitclaim deed on February 2nd, 2022?
Oh, thank you.
And
Because I done
Mr.
hired-
Meeks is going to take the Fifth Amendment at this point.
Okay,
Take the Fifth Amendment, Mr. Meeks.
okay.
All right, well,
This is so awkward. This is so awkward. Oh, good Lord. Generally speaking, you know, if the answer could incriminate you in a pending criminal action, the notion of the Fifth Amendment makes sense. But she just sounds like someone who doesn't know what she's talking about.
what was the question?
I asked Mr. Meeks what his intent was when he signed and filed the February 2nd, 2022 quitclaim deed on the Denfield property.
And council, we understand that's a mens rea issue of intent. So Mr. Meeks is at this point taking the fifth by the advice of his counsel. Let's move.
Who's hammered, by the way. Okay, I don't know. I'm saying it's possible. It's possible that his counsel is hammered. I'm not making accusations. I'm saying the possibility exists.
on.
Well, you don't get to say that. So what criminal penalties, Miss Alexia, would be involved in this? Do you have a penal code section?
I can certainly, Your Honor, respectfully submit that to the court.
Okay. So, does your client not need to answer the question asserting?
Let me answer
his
the question.
right-
I don't
his-
care about that. Let me answer my question.
Mr. Meeks,
I answer the question.
Mr. Meeks. Let's move on to the next question. That's what the advice of counsel offers you.
Well, he didn't answer with his assertion of his constitutional right. You just
Let me
told him
answer the
to.
question.
That's all.
Yeah.
Your Honor, respectfully, I am advising my client to move on to the next question.
He hasn't asserted his right yet.
That is so incredibly stupid. She condescendingly tells the judge is on top of this. Judge is saying, you've informed me that he's about to assert his Fifth Amendment privilege, but he has not done so yet. And she condescendingly comes back with, Your Honor, I told him to move on. I mean, you don't need me to tell you, but I, in case you need to hear it from an attorney, I can't tell you how just horrific that is.
He is now. Curtis, assert your right.
Come on, Curtis.
Okay,
And
next
let's move
question, Kuma.
Assert
And
your
let's
rights, big
move
dummy.
on. You
We
invoke
still don't have an assertion of a constitutional
your-
right.
So there's that.
Invoke your right to counsel immediately, Curtis, and then we move on to the next question.
Move on
That's
to the
how
next
it goes.
question, Kuma.
All you have to say, Curtis, is I invoke my right to counsel. That's all
I
you have
invoke
to.
my right to counsel.
All right, let's
Good
move
job,
on.
Curtis.
Let's
You
go.
did it.
I'm not sure that would cover it, but go ahead.
Okay, yeah, I think
I like the judge. It's like, okay, close enough. We've got a life to lead here.
are you invoking your Fifth Amendment right against self-incrimination, Mr. Meeks, or not?
He has a Fifth Amendment right to the U.S. Constitution, and that's what he's doing.
Now she's going to condescend to opposing counsel. Oh, it's so good. It's so good.
So let's move forward, please.
Is that correct, Mr. Meeks?
He
right.
only has to say it one time.
His witness, he asked a question. If anyone thinks it's inappropriate, at this point it's the judge because it's procedural and he's trying to help out the judge. Not help out, but to clarify it for the record. You're not the dictator, judge, and ruler of the universe. You got to let it go. It's his witness. He's asking questions.
Well, I think that you're harming your client. Doesn't he need to assert his right to his Fifth Amendment right to against self-incrimination? Isn't instead of just
It's not.
invoking-
It's not. So
Hey, I'm talking. Doesn't he need to specifically say that to protect your own client? Not just, oh, I invoke what my counsel said.
Curtis, what do you have to say?
What on earth? She's asking, the judge is asking the attorney, and she defers to her client, who is as dim a bulb as you can find. And the reason is because she doesn't have the answer, of course. It's so awkward to watch.
Answer all the questions they want me to answer. Ain't nothing criminal or nothing whatever Kuma's want to happen or none of that. It ain't nothing that anybody that spent over $800,000 to $900,000, almost $1 million on the property, ain't nothing criminal about that. They can say whatever they want to say.
Thank you for that inane, irrelevant rambling, Curtis.
You know, if he got a deal with his client, Brenda with Allen, that's their business. I don't know what they
You
got
get
going
0
on.
points. May God have mercy on your soul.
I answer whatever question they want to answer for me.
Well, the question was, what was your intent?
My
And
intent
that's
on
a
what?
violation of his Fifth Amendment rights.
He hasn't
And-
asserted it yet. He said
I'm
he'd answer it.
advising my client to not answer the question.
You don't get to do that. This isn't a deposition.
That isn't how this works. Oh, right. You can direct your client not to answer a question in deposition, and then you can certify the question. The judge can rule on it later. But you're in court in front of the judge. They're there to rule. Oh, good
Or
Lord.
later, a judge will decide. A judge is here. I'm deciding. Okay? He needs to assert on his own accord at your counsel whether he asserts his Fifth Amendment right against self-incrimination
I assert
or answers the question posed by Mr. Coomer.
He
it.
sure
I
does.
assert it.
Okay. Thank you. Next question, Mr. Coomer.
Okay. I asked the court to admit Exhibit D2, the February 2nd, 2020 quitclaim deed into evidence.
Any objection?
What is this? What is it?
This is
Correct. There is an objection. I don't know what this is. I'm new in the case, so we're gonna have to have a continuance. I don't know what this is.
Okay, overruled.
Yes, but I'm
Defendant's
not getting into
Exhibit
it.
2 is admitted.
You're absolutely correct. I wanted to say, but no problem.
Did you or the lawyers ever produce the quitclaim deed marked as Exhibit D2 through discovery?
He doesn't know. He doesn't know. He said.
Miss
No, the-
Alexa,
All right.
The
Miss
phone,
Alexa, if you can,
You can't answer for your client. They don't know. You can't do it. If you could, we would all do it on every question. Oh, good Lord.
continue to interrupt these proceedings without first saying objection and then a rule of evidence or procedure or statute or constitution, I am going to hold you in contempt. This is the second time I've had to tell you this, and it's happened many more times than 2. Okay? You don't get to instruct your client. All right, except when we're talking about, what we just went through that should have taken 2 seconds instead of 2 to 3 minutes. All right? What was your question, Mr. Kimmer?
My next question is it true that on August 31st, 2022, you executed and filed a second quitclaim deed regarding the Denfield property?
well, putting it back into AACSI like you wanted it to be. Is that what you're saying? Yes, I remember that.
Okay. Mr. Bueller, can you put Exhibit D3, August 31st, 2022, quitclaim deed on the screen?
Oh, here we go.
Mr. Meeks, do you recognize the document marked as Exhibit D3 as the August 3rd, 2022 quitclaim deed that we discussed?
Right. Put it like you told me, put it back into
Right.
AACSI. The way I put it in is the way I put it out and put it back.
Okay, and did
But
you
you wanted a
sign?
special warranty deed.
Yes, a question required a one-word answer, and he starts getting the explanation the entire time. And of course, it's because the guy's full of it.
Okay, so you do recognize this quitclaim deed, correct?
Yes.
And then you did review and sign this document on page 2, is that correct?
Yes. After we did this, you said you were dropping the lawsuit. Then when we signed and everything, you said a special warranty deed, but you didn't explain that to us the first time. But that's
Again.
correct. Everything on there correct.
Again, Mr. Meeks, did you also review and sign this document on page 2? Yes or no?
I'm telling you that, Kuma. I signed this. You said.
Okay, that's all I was asking.
Every question gets a Boomhauer, filibuster afterwards. Every single one. Oh, it's too good. This guy, he. I think he's a good attorney, but I don't think he's got a lot of litigation experience. Is my sense. So, like, he can do it, but it's sort of clumsy.
As if you signed this, and you're
put it
agreeing
back
you
into
signed it.
AACI. I'm saying I put it back in the ACSI like you told me to. Then once we did that, you said I'm still not dropping the lawsuit. Okay, well we don't drop the
Not
lawsuit then.
even
Let's keep going.
sworn, so, I mean, I'm sorry. You may proceed, Mr. Coomer.
Thank you. Mr. Meeks, did you sign this document in an attempt to transfer the Denfield property back from Top and Ball Properties LLC to AACSI Investments LLC?
Yes, you told me to do that, to put it back into ACSI because you dropped the lawsuit.
At this time, was any consideration given for this transaction between?
What's he talking about? You told me to do it. This is opposing counsel. He's suggesting that he was previously advising him on the transaction, which would mean that he's conflicted out of this. I'm sure it's all nonsense. This is just a nightmare.
Top and Ball Properties and AACSI.
Say that one more time.
At the time this deed was signed, was any consideration given by Top and Ball Properties LLC to AACSI or vice versa?
I just know you told me to put it back. You told our lawyer to put it back into ACSI.
Okay.
Oh, sweet Jesus. What?
Any consideration being paid for this quitclaim deed, yes or no?
You say any consideration of my being paid. What'd you say?
Did any money other than this quitclaim deed or any other property transfer between Top and Ball Properties LLC and AACSI Investments during the August 31st, 2022, when you signed this quitclaim deed?
No, they said that you paid out
Okay.
to Miss Brenda on some other things,
Okay,
but
that
not
would make
this. I
sense.
didn't get paid nothing. They
Okay,
paid
so
you.
no
I didn't get paid
consideration, to be clear, no consideration accompanied this quitclaim deed, correct?
Objection.
You the only one that's been getting
Assumes
paid.
facts not in evidence.
Burrell,
Okay.
was consideration paid or not, Mr. Meeks?
Nobody wasn't paid, Your Honor. But Kuma was.
What?
By whom?
I guess from his clients, Alan and Miss Brenda, I guess.
I represent to the court, I was not paid for this quitclaim deed. This is a quitclaim deed you signed and you filed, is that correct?
No, we got told, Jameson told me what you told him to sign it, and we're going to drop the lawsuit with Top and Ball. So that's what we did, put it back into ACSI. Then once we did, you said, nope, I'm still not dropping the lawsuit.
It's hearsay. It's
So
not
that's where we
responsive.
at today with
You
that.
got to object.
Okay. I asked the court to admit Exhibit D3, the August 31st, 2022 quitclaim deed into evidence.
Any objection?
No
Jameson-
objection.
Is what we need right now.
Defendant's Exhibit 3 is admitted.
Mr. Meeks, did you or your lawyers ever produce the quitclaim deed marked as Exhibit D3 through discovery?
I have the, you say that I order
Hmm.
lawyers.
May
You said-
we see that clearly?
What part of Exhibit D3 do you want to see?
Mr. Coomer, have you ever been Curtis Meeks' attorney?
I have never been Curtis Meeks'
All right.
attorney, but I am doing examination right now.
Okay.
Okay, so that makes
Alexia,
sense.
I'm sorry, but I am holding you in contempt for again interrupting the proceedings outside of the rules of civil procedure, when you are on, your client is on cross-examination, really the only thing you can really say is object and give me your reasons under the law. And I've warned you 3 or 4 times, I am holding you in contempt. You may proceed, Mr. Coomer.
Thank you. Mr. Meeks, are you aware that last August and September, my clients attempted to mediate with Top and Ball Properties LLC, ACSI Investments LLC, and you?
You say that we have an examination on, well, say it again, what'd you say?
I'm saying that last August, September, I made requests to your attorney, Jameson Watts, to mediate this case. Are you aware of that?
Yes.
And did you refuse to mediate with either one of my clients at that time?
No, I mediated with one of your clients, with Alan Guyton. Yes, we mediation, and we was in mediation, so I did do that.
Okay, let me clarify this now. I have never represented Alan Guyton. I represent Brenda Walton and Walton Homes LLC.
No,
Do you understand that?
No, he told me that you gave him all. He told me that Alan told me you put he told me that you represent him in some of the cases, and I don't know which one it was. And you also represent Brenda Walton. So I just want to know, which question are you asking me? Is it about Brenda or Alan? Because I don't know Brenda. I don't know Brenda from anything. I know Alan, but I don't know Brenda.
Okay, let me be clear. Did you refuse to mediate with Brenda Walton and Walton Homes LLC last August and September?
Oh, you talk about Brenda? Oh yes, I didn't. I refuse on that because I don't know her.
Oh, that Brenda, that one, the one you were referring to the first time. Clearly,
I'm going there talking about it if I don't know this lady.
Okay. But you went ahead and had a mediation with Alan Guyton, is that correct?
Yeah, we had a mediation with Alan.
Okay. On
with
September,
the other client, yeah, Alan, we had a mediation with him.
Alan Guyton is now my client. He is represented by Rob Holcomb. Do you understand that?
That's your friend that you advised them to. Yes, I understand that.
Okay, so you mediated with Dean Kilgore and Rob Holcomb in this case, but you refused to mediate with me, Brenda Walton, and Walton Homes, correct?
All right, can we move on, please?
Is that an
There was
objection?
a question on the table. You can't just interrupt Miss Alexia, the proceedings. You were not the judge. You weren't elected to tell a witness to move along while there's a question on the table. I have thrice told you, please do not open your mouth unless you have an objection. And you again did it. So I'm upping your contempt. I'm going to issue a show cause order. You'll have an opportunity to argue why you shouldn't be held in contempt twice so far, 2 times. Answer the question. Do you remember it, Mr. Meeks, or do we need to read it back?
I need Kuma to re-say it.
I don't think I remember the whole question at this point.
Okay, Ms. Albrecht, would you please mind reading back the question?
oh sweet Jesus.
I'm scrolling.
Thank you.
Okay, question. So you mediated with Dean Kilgore and Rob Holcomb in this case, but you refused to mediate with me, Brenda Walton, and Walton Homes, correct?
I don't recall their names, but I know Alan was there. So I don't recall their names who I was mediating with. And I don't know Brenda, so why should I mediate with her? I mean, we're talking about some money that I don't spend $900,000 on, and nobody's talking about that. Let's ask them questions. Well, Curtis, how much money did you spend? Or Brenda, how much money did you spend? Or Alan, how much money? I want to hear them type of questions. Well, what is this lien? Is it valid or not? Answer them questions, cool. So, like, get me to that. Like, did y'all spend any money? Yes or no? No. Did Curtis spend any money? Yes or no? Yes. Like, let's hear that type of stuff. Because there's always a lien up there. It was a $250,000 lien, and nobody's saying it. The judge.
Okay, it's on. This is on Jason here to tell this witness to shut up and answer the question, or object and say, Judge, please instruct the witness to answer the question. He just lets him run over him time and time again. He's good, but he's just not used to this sort of adverse witness, and it's actually fairly common. You got to have some game to deal with that.
Judge or nobody can move on that and say that lien was valid or not. Nobody don't want to get to those answers.
Okay,
they want to talk
we're
about some other
wasting
stuff.
court time. Can you please start earlier when you can see it's non-responsive or running out of time?
I will, Your Honor, my apologies. On
Okay.
September,
We're gonna have to get this done.
I will speed along, Your Honor. On September 30th, 2022,
Oh,
did
here we
Top and
go.
Ball LLC receive discovery in this case?
Your Honor, at this point, I am going to have to withdraw on this case. So the
That's
case,
denied.
well, the case cannot proceed further.
You can't withdraw mid-testimony during a hearing. Oh Lord, I didn't see this part. Holy. I can't even believe it. I mean, she's doing a horrible job. She'd actually be doing everyone a favor. You could request, but you would have to give some basis and request. And she just announces it to the judge as if the judge has no choice. Holy. Oh my God, here we go.
So I must I must proceed with a withdrawal.
Okay.
I do not feel that the judicial temperament has been fair toward my client.
Oh, good Lord. If you're withdrawing, you have some reason for doing that. If you're saying you don't like the rulings, you can appeal them. But I mean, this is just not good. This is just not good. You're sitting here insulting you. First of all, you have no basis to withdraw. It's too far along. You gotta complete it. Secondly, you're now just stepping on the toes of someone who's clearly going to make the determination on this hearing right now, which doesn't matter much because you have a complete loser. Your client's full of it. That much is clear.
And I am not proceeding further. So that's it.
Homer, you can add me some more questions. I'm here to answer.
The judge is like, you can see her face. She went through all these things. She's like, that is so freaking stupid. I don't know where to begin. I mean, she's not saying it, but that's the thought part. Like, I don't even know where to start with this. I've never seen anything so dumb. Okay, all right. Let's see what she does.
I
I
appreciate
can't wait till the
And
judge
you
rules
and
on
I
it.
have,
That's what I'm waiting
and
on.
I have Curtis. I have accurately and fairly represented you. I have invoked you to
All right. Okay, I'm cutting you off.
Yeah. This
Mr.
is- at this
Kummer, your
point-
next question, please.
Thank you.
I am, Your Honor, what I demonstrate or consider with your behavior is inappropriate.
Okay, well, you can file something with judicial conduct or That
I
could be
know.
Whatever.
And this,
And
this
you are now
hearing-
being held in contempt for interrupting again for the third time. I've actually helped your client because you were not instructing him properly on how to invoke the Fifth Amendment. So actually, I've been fair to your client. You have been, I think he would be better off without you, frankly. So, but I am not excusing you. So don't,
I never made an appearance.
okay.
Ooh, I have never seen that in over 25 years of practice. It makes sense, but I don't know. But I understand it. This is an extreme situation. I don't know, so I shouldn't be making. I'm not making accusations, but my guess is, by observing this, that this woman is altered. I think she's drunk. I think this attorney's drunk. She knows enough law that it makes me think that she is an attorney, but the way she's handling it is so bad. I don't think she's kind of like, I had a couple drinks. I think she's wasted. That's my guess. I could be wrong, but that is my impression as I watch this.
You did make an appearance. Okay. This is like, okay, Mr. Comer, you may proceed.
Thank you, Your Honor. Prior to the foreclosure date of January 3rd, 2023, did you receive my application for a temporary restraining order?
Meanwhile, we got Steady Eddie over there, and he has no way. He's doing fine, but he's just like chugging along in the most basic way possible. He has got no game to deal with this whatsoever. He's doing fine, but he can't calibrate and adjust to it at all. It's funny.
I receive your application or just receive an email from me?
Did you receive a copy of my application for a TRO before it was heard?
No, nobody. You mean the guy that came out to my house and tried to serve me? I saw him on the camera and he tried to serve me, but I didn't get served at all.
Did you file a response to my temporary restraining order?
Yeah, I responded to some because I sent your email.
Okay. How did you respond to my temporary restraining order if you never received?
I sent an email and it said something about a TRO, and your other friend helped me out with the Derwin McKee. You're all buddies.
Okay. So you did receive my application for a temporary restraining order and you did file a response to that application. Is that correct?
Yes.
Okay. Were you personally served with the temporary restraining order on January 3rd, 2023?
Unbelievable.
Say it again.
You don't get to belt out unbelievable after the opposing counsel posed a question on their examination. If you think it's unbelievable because it's inappropriate or wrong, you say objection and state the basis for it. If not, you shut your hole. That's how this works.
That will be a fourth contempt for another
Oh,
interruption.
I'm sorry, Your Honor. I thought that it was muted.
Okay, I'll take that one off then.
Oh, bullshit. No way. And the judge doesn't believe it either, but she's trying to placate her a little bit. She literally just wants to get through the freaking hearing, which is appropriate. That's all the judge is trying to do.
You're still at 3.
Were
You may
you
proceed.
Thank you, Your Honor. Were you personally served with the temporary restraining order on January 3rd, 2023?
I believe so.
Could be the case.
Okay.
I think it
Mr.
is.
Bueller, would you put Exhibit D11, Meek's temporary restraining order, up on the screen?
That's possible.
Do you see where the citation states that you were served with the TRO writ on the 3rd day of January 2023 at 9:50?
Are you talking about the TRO for the foreclosure deal where I loaned out some money, the same thing as Park Place Funding did, and I didn't get paid, and I actually foreclosed? So you talking about that TRO?
Objection, non-responsive. Instruct the witness to answer the question. That's how this is done.
I'm
The
talking
Park Place
about,
Funding did the exact same thing that I did. Like the Park Place Funding did it. I'm doing the exact same thing Park Place Funding did. Because we're hard Monday lenders.
Oh, I'm going to lose
But
my
I
freaking
get
mind.
retained on it though, right? Like I get in trouble because I wanted to foreclose. That's what you're talking about, the TRO? Oh yeah, I see
Okay,
it.
so,
I see it.
Your Honor, what would you like me to do in this position?
Shut your hole.
You just need to sit there and be quiet. She said we got to be quiet and let Kuma talk.
Her client even agrees with me.
Unless you have an objection under the rules of evidence or procedure, statute, case law, or constitution, one of the two that govern us.
I like you, Your Honor. You're a nice lady.
Oh,
I like
no.
Well,
you.
thank you very much.
When your client sucks up to the judge after he smacks you down, that's not good. I don't think I've ever seen that ever in my life.
All right, so I will say nothing and not represent my client.
Let Kuma just let him answer me the questions.
Your Honor, may I proceed with my questions?
Yeah. Did you offer D11?
I haven't yet. I'm getting ready to. I'm just trying to get Mr. Meeks to tell me if he sees the citation that states he was served on January 3rd, 2023 at 9:50 a.m.
The judge could ask if she's altered. Generally speaking, you would try to do that privately on a break or something like that if you really have those concerns. The judge could go that direction, and that may actually happen. But I think we're on Zoom, so it's hard to ascertain, and it makes it very difficult.
I wasn't served, but I see the paper that you got right there.
Okay. Do you remember being personally served by a Travis County constable with this TRO, temporary restraining order application, and TRO on January 3rd, 2023 at 9:50?
I just told you I wasn't served, Kuma. How many times you gonna keep asking me? I said, explain it. I wasn't served.
Were you served with any paperwork on January 3rd, 2023 at 9:50 a.m.?
I wasn't served. You probably had my agent was served, Ricky Henderson. He probably was served. I wasn't served.
So you received no papers from any constable on January 3rd, 2023?
No. Because don't they have cameras on their body where they can see you? Tell them run them cameras back.
I have a citation returned by the constable that states that you were served on January 3rd, 2023 at 9:50 a.m.
Well,
Well,
but
I
that's not
wasn't
a
served.
question. Move along. Next question.
Okay.
Thanks, Greg.
Did I show you this same citation at the hearing on January 11th, 2023?
What you say it again?
Okay. Did I show you a copy of this same writ of TRO and citation at our hearing on January 12th, 2023?
You said that you showed me?
Yes.
No, you didn't show me anything.
Did you attend a hearing on January 12th, 2023?
Yes, and then that's why we're here today. Because we scheduled it today.
Exactly. And during that hearing, you remember me showing you a PowerPoint presentation?
A PowerPoint?
Yes, a PowerPoint presentation like I did earlier, where I went over the documents in this case and I explained how you violated the TRO and I showed how you were personally served with the TRO. Do you remember that?
I mean, you showed a lot of papers, Kuma, but I don't be understanding what are you trying to get to. You just trying to say you trying to take my money? You want me to give all my money to you? To you and your client, Ms. Brendan Allen? that
No,
what
all
you're
he
saying?
really wanted you to do was sign a special warranty deed, putting the property back
Okay.
where it was supposed to be. That's what he
Okay,
wanted.
well,
And he gave you a lot of
okay, but
opportunities to do that.
well, I wasn't doing it. I'm not listening to Coleman because it's not his property. We're going for court for a lien, $250,000 lien. That's
And
what we're
good
going to
luck
court
to
for.
you.
I'm not right. I hope the luck do change. I hope it changes. I'll be glad when you rule on it. I want a judge to rule and say, Curtis, you lost. All the money belongs to Coomer and Alan and Miss Brenda, and that's it. And I'll be happy with that. I'll be done. I don't have nothing else to say. Because we'll be over with.
Exactly. Do you understand that I've told you today and I told you on January 12th in both hearings
You can't
that
tell me nothing.
hold on, let me finish my question. That you violated the temporary restraining order in this case.
I didn't violate nothing. That's the same situation that Park Place Funding. If I violated something, Park Place Funding violated something. I didn't violate nothing.
Have you ever reviewed the temporary restraining order in this case?
I reviewed it
Okay.
after the fact.
Do you understand that the temporary restraining order prevented you from encumbering this property, that it prevented you from transferring this property, it prevented you from foreclosing on this property, but you did that anyway?
No, the lawyer told me that the TRO wasn't active yet. So it wouldn't stop me from foreclosing on the property. It just said the TRO is coming, but it wasn't active at the time. So the lawyers, I'm hiring all these lawyers and paying them, and they tell me what to do, but it looked like all the lawyers tell me wrong.
And that could be, Mr. Meeks, but just so we're clear, you were aware of the TRO before you transferred the property, the Denfield
Don't worry.
property, on January 3rd, 2023. Is that
It
correct?
gets worse.
You say,
Objection.
was I aware of it?
Yes.
Objection.
What's your objection?
It's asked and answered, and it also assumes facts not in evidence.
Overruled and
No.
overruled.
Yeah. No, Kuma.
Well, you just said you consulted an attorney regarding the TRO. You had the Denfield property transferred.
Wait and see.
So how did you consult an attorney regarding the TRO and then have the property transferred?
An objection to counsel testifying. Facts are not admitted in evidence, Your Honor.
Can you rephrase that, please? And are you still gonna use this service? Or did you offer it? Is this D11?
Yes, Your Honor.
It's hard for me to see the witnesses, and I'm supposed to be evaluating the credibility of the witnesses, and it's taking up a lot of space.
Okay, thank you, Your Honor. We offer Defendant's Exhibit D11, the Meeks temporary restraining order writ into evidence.
Any objection?
Absolute objection. It is a forgery.
Over.
Absolute objection. That's the dumbest crap I've ever heard. That's an absolute objection. Oh, she may have an affidavit of truth she can file in support of her absolute objection.
Overruled. D11 is admitted.
Okay. Now, Mr. Meeks,
This whole thing is awkward. First of all, I keep beating up on him. He knows his stuff. He knows his case. The lawyer who's got him on, but he's not a litigator. He's a transactional attorney. I figured out what's going on here. So he's okay. He's going through the case and sort of doing it in workmanlike fashion, but he's not used to day in, day out getting lied to like me. So I after years of this, you learn how to redirect these things a little bit better. But that's my theory. So he's just sort of awkward and out of place in a hearing. Not horrible, but just not good at it. And she's insane. I don't know. altered or just not here today. I don't know. And this guy's completely full of it. Oh, the judge is losing her mind.
You testified that you spoke to a lawyer regarding the TRO, and then you went ahead and transferred the property. Is that correct?
Objection to
saying
form
transfer?
and foundation.
Overruled.
Which lawyer, counsel, if you would rephrase, please?
He could, but
Any lawyer.
he wants to proceed.
Which lawyer? It counts.
You're speaking out of turn again. You're being warned.
If you would
What
rephrase.
was the question?
Now
The
that
question
would make
is,
sense.
Mr. Meeks, you testified that you consulted a lawyer about the TRO, and then you transferred the Denfield property because you thought it was okay. So my question is, were you aware of the TRO before you transferred the property?
Yes, just on that day when it got foreclosed on.
Okay, thank you. Thank you. Mr. Bueller, could you please show Exhibit D8, the January 3rd, 2023 trustees?
I just got disconnected.
We can still hear you.
Hi
Mr.
there.
Meeks,
Hi there.
Mr. Meeks,
I just got disconnected.
Mr. Meeks, can you, do you recognize Exhibit D8, the January 3rd, 2023 trustees deed?
Yes.
Okay. And do you see on page 1 where it says the trustees deed and the date January 3rd, 2023?
I see it.
Okay. Do you also see the address and the description of the Denfield property on the bottom of page 1?
You.
You say what?
I say on the bottom of page 1, it says property address, and it says 1132 Denfield Street, Austin, Texas, Austin, Travis County, Texas, 78721. Is that correct?
Yes, the property I own. Correct.
Okay, so this trustee's deed is for the Denfield property. Is that correct?
Yes.
Okay. Do you see Top and Ball Properties LLC listed as the purchaser
Sure is.
guarantee
It's
in
perfect,
this
bro.
document? A grantee, purchaser grantee.
I see everything that you're telling me, Kuma. Like, what is your question? What you trying to know?
I'm just trying to make sure you're familiar with this deed. You have
You keep
personal
asking me,
knowledge.
do I see it, brother?
I am.
I see everything right there, what you're saying.
You asked me, do I see it, brother? Oh, it keeps getting better.
Okay, so you agree with me that this trustee deed has Top and Ball
I
Property?
don't agree with you with anything. I didn't say I agree with you. I said I see it. I don't agree with you with anything that you said. I don't agree with you with nothing.
Okay.
Because you don't have no money involved. You're just trying to scheme and get money out of somebody. That's what you're trying to do. But I just want the judge to go ahead and rule on the situation so we can be through with it.
Okay,
You know,
Mr.
I
Meeks.
want to go give me a life sentence. Say, hey, Curtis, you get a life sentence. Rule that.
They really
Mr.
do.
Meeks, who is listed as the purchaser grantee on this document? Is it Top and Ball Properties LLC?
You say, is it Top and Ball Prop? You say the grantee, the owner?
Yes, the
He
purchaser
doesn't
grantee.
understand any of these things.
Yeah.
He literally
Okay,
doesn't.
Top and Ball Properties LLC.
Let's move to page 2 of Exhibit D8. Do you see the time of the sale as 11:07 a.m.? Is that correct?
You say what?
It says that the sale time is 11:07 a.m. and the sale date is
I don't-
January 3rd, 2023. Is that correct?
That's what it says on this paper right there.
Okay. And do you agree that this was less than 2 hours from the time that you were served with the TRO?
It sure does.
I wasn't served, so I don't know what
Okay.
you're talking about at that time.
Okay, it's less than 2 hours from 9:50 a.m. on January 3rd, 2023. Is that correct?
Objection, asked and answered.
Overruled.
Mr. Meeks, do you also see in this trustee's deed marked as Exhibit D8 where it says Curtis Meeks, mortgagee, directed Ricky Henderson, trustee, to administer the trust provisions?
Okay, yeah, I see that.
Is this statement in the deed correct? Did you direct Ricky Henderson
bad.
to default on a deed of trust and to administer the trustee provisions?
And it still gets worse.
Yeah, he was at
Objection,
work.
objection. I advise you to take the Fifth Amendment, Curtis.
Where we at with it now, Kuma?
And either you're going to take the Fifth Amendment or you're going to answer my question.
I
I'll take the
advise
Fifth
you
Amendment.
to take the Fifth Amendment,
Okay,
Curtis.
he's asserted his right. Next question, please.
Okay?
Thank
You understand by directing Ricky Henderson to default on the deed of trust, he was enforcing the deed of trust against the TRO and violating the TRO.
And take the Fifth
Nobody
Amendment
was
again,
enforcing anything.
Curtis. You're to take the Fifth Amendment again. Invoke your right.
Take the Fifth Amendment.
Okay.
All right.
Your Honor, I ask to admit Exhibit D8, the January 3rd, 2023 trustee's deed into evidence.
Any objection?
All objections. Curtis Meeks has invoked his Fifth Amendment. And-
Okay, he is offering.
All objections. I've been doing this a long time. I've never, ever heard an attorney, a pro say, anybody say all objections in response to any objection. Never once. This is the first time. Oh, that is delicious.
Defendant's Exhibit A, the trustee's deed executed, I believe, January 3rd, 2023, if I read it down correctly. Do you have an objection to the admission
Yes.
of that?
I have objections to everything. My client is now advised to take the Fifth Amendment.
Overruled. Okay.
Well,
Defendant's
you don't
Exhibit
get to
A was
overrule him.
admitted.
I object to.
Move forward. My client is
Wait, did the client object too? I'm trying to keep score here. I'm trying to, it's like, it's like, it's too much.
taking the
Cool,
Fifth
so,
Amendment.
Okay.
No,
Miss
not
Alexis,
one more.
You want to do
question
number
is to be
4? You are
responded.
speaking out of turn again.
I am advising my client to speak to.
Look, there's
the
no
Fifth
question
Amendment.
on the table. You are again speaking out of turn.
Contempt
Do
number
you
4.
want a fourth issue on this show cause order is getting longer and longer?
Your Honor,
Quit speaking out of turn.
Your Honor,
Shut your hole.
I have advised my client to take the Fifth
There's
Amendment.
no question on the table.
There have been many.
And he
Okay.
asserted his rights.
No, I have
did.
advised my client. to take
did.
the Fifth
And
Amendment.
he did it 3 times. The first time I saved him because you kept saying the wrong thing. And then he finally said the right thing to invoke the Fifth Amendment. Now,
She is
there is
right.
a fourth
Right,
contempt for speaking out of turn.
Curtis,
Mr.
you are
Coomer, you may
to
proceed.
take the Fifth Amendment
Sure.
immediately.
Your Honor,
Okay.
was Exhibit D8, the January 3rd, 2023 trustee's deed admitted into evidence?
Yes.
Okay, thank you, Your Honor.
No, that makes the competent ones more valuable.
Mr. Bueller, will you please put exhibit number D9, the temporary restraining order, up on the screen?
Oh,
And
here we go.
can you blow it up a little bit so everybody can see?
This
And
is
can you slowly scroll down? This is the order granting application for a temporary restraining order.
this
And
is
then if
worse
you can
than I even
scroll
anticipated.
down, keep scrolling down. We're looking for section 2A. Okay. Basically, if we can go up just a little bit, the court orders that Curtis Meeks and Ricky Henderson, as well as any of the
Curtis, you were to take the Fifth Amendment, your right to the United States Constitution, not answer one more question.
There's no
Miss
question on the
Miss
table.
Alexa, can I finish my question before you object?
Hold
No,
up.
Why everybody
you
arguing?
you
right.
cannot trample on his
Stop
Agreed.
talking.
constitutional rights.
Stop talking.
Curtis,
I'm
take the
talking
Fifth
to
Amendment
you, Miss
immediately.
Alexa. Stop
Curtis,
talking.
end this now.
All right.
Goodbye.
Okay. Mr. Meeks, what I'm showing you is exhibit number D9, which is the temporary restraining order issued in this case on December 30th, 2023. Have you ever seen this document before?
Malpractice.
I plead the fifth.
Okay. And do you remember me showing you this document at the January 12th, 2023 hearing?
I'm gonna plead the fifth.
Okay. And
She sure did.
if we
It was
can,
a rage
Let the
quit.
record reflect that Ms. Alexis has dropped off.
thank you, Your Honor. And can
I
you,
don't know what to do about that.
I've never seen it before, Your Honor, but this case is a lot of firsts for me, and it's confusing, but I just want to get through and do what we need to do.
You
I know.
can't get through Como because you just
But
Okay.
Mr. Meeks had a lawyer, although she, in my opinion, was not doing great.
No, she
Still,
wasn't.
he's entitled
But-
to a lawyer, and she made an appearance. How do we continue without her?
that's the
I
situation.
could refer, okay, the court is continuing in this case on its own motion. We are going to be in recess. That is the order of the court for now.
Well, there we go. I guess that's all I have. I've never seen anything like that. The judge, that's interesting. So she drops off and just walks out, and the judge doesn't want to continue the hearing. And I understand that because this guy had an attorney, and I mean, she just buried herself. She buried herself with the licensing authority, with contempt, with everything. You can't just sit there. The contempt thing, you can purge contempt, you can fight about it, you can do lots of things, but you walked out of a hearing because you didn't like the judge's rulings. If I walked out of every hearing where I didn't like the judge's rulings, I'd never stay to the end. That's not how it, well, not never, but rarely. If you're an attorney and you're in an extended hearing, there are going to be rulings you don't like or disagree with. That's just the way it is. You don't get to walk out. If you don't like it, you make a record, you take it up on appeal. There are a lot of different things you can do. You can try to squeeze that issue into another action or venue somehow. I mean, I'm not going to bore you with it, but you don't walk out. I mean, that's the kind of thing that gets your license pulled. I mean, I don't know what'll happen. I don't know what the fallout of this will be, but you've just videotaped, ethical violations, legal malpractice, potentially, and sanctions. And you've made a record of it. for the world to see. It's absolutely crazy. And the judge she just didn't even know what to do. She could have said, okay, fine, you go forward. But the problem with that, and every attorney, and the judges and the attorneys think this way too. It's like, well, we've got due process concerns, and anything that we do from here forward in this hearing, then the client can go back and say, no, I want it vacated. My attorney walked out. And it's a damn good argument. So now we're wasting our time. Oh, that's just wild. That's just wild. But her up talking and saying, "Oh, let's move along," and telling the judge, telling the judge the way it's going to be. Oh, I do think she's a lawyer because she said some things that made some sense that most of the general public wouldn't do. So I get the sensation, I don't know, but it's certainly speculated a lot here, and that is my guess. My guess is that we've got a licensed attorney who's honestly not very good and altered. That's my impression. That's my fair impression. I don't have any proof of it. I wasn't there. I didn't breathalyze her. Not at all. Yeah, that was probably, she's probably just ready to pass out and just created a conflict and walked. By the way, the hearing was almost over. But I think the judge probably made the right call under the circumstance. I wouldn't continue without, you start a hearing and the represented, and then the attorney walks out. It's one thing to go after the attorney for it, but the client, you don't want to stick them with that. Now, one of the problems is that we went through it before, is he went through 5 attorneys and then he ended up with her. And what this is my speculation. I don't know. But what this is this guy's fraudulent and full of crap. That's what I gather from watching this hearing. He's completely out of it. He doesn't answer any questions. He's fraudulently conveying properties. He's not a good guy. Most attorneys don't want to represent him. Probably doesn't pay. If he does that, he probably doesn't pay his attorneys. So you've got a desperate client getting the only attorney he could get, and a desperate attorney getting the only client she could get. And that's what you have. I don't know, but that seems to be how this occurred. But it was it was something to behold. Thanks again, Lauren and Mikhail, for doing that. I wasn't even gonna do a video today, and then I saw that was suggested. I saw a bit of it, and I'm like, okay, I've got to go in on this. Even though the subject matter was so boring, this quitclaim deed, and we've got the we've got the attorney who's just doing it, like starting with a PowerPoint presentation and then not knowing how to handle a witness, like knowing how to make a case, but not knowing how to handle an adverse witness. That was the lack of litigation skill. I don't know. I'm not saying I'm perfect at it, but like I would have just done things a lot differently. It would have been a little ugly. Let's be honest. I would have made that witness uncomfortable intentionally. Not because I'm a bad guy, but because that's what needed to be done. Just saying. All right. Thank you all for coming out. I'll see you soon.